Mr. Chair, members of the committee, this amendment was requested by Representative Monforton. It would make some changes on page 49 in two places, on line 17 and line 20, and would provide that essentially that unless the compact states otherwise, this amendment relinquishes all tribal rights and claims east of the Continental Divide. Mr. Chair.
Representative Monforton.
Thank you, Mr. Chairman, members of the committee. Let me let me first apologize for my voice, which seems to be getting worse by the day rather than better. This amendment is based on claims of Aboriginal rights by the tribe east of the Continental Divide in Montana. Much of this compact arises from the Hellgate Treaty of 1855. That treaty, by its terms, applies only to the territory of Washington as it existed in 1855. That territory consisted of what is present-day Washington, part of northern Idaho, and part of northwestern Montana up to the Continental Divide. The treaty, by its terms, does not apply east of the Continental Divide. CSKT is claiming water rights east of the Continental Divide based on Aboriginal rights, purported Aboriginal rights, rising out of federal common law. The tribe has stated consistently that if the compact doesn't pass, and they've stated this for several years, that if the compact doesn't pass, they will file, I think it's at least 10,000 claims, many of them east of the Continental Divide. They have retained an expert by the name of William Farr. Excuse me. He is a professor at the University of Montana, a historian, and he has written that the tribe has, throughout the centuries, occasionally hunted and fished east of the Continental Divide. He has also admitted on several occasions that lands east of the Continental Divide were either controlled by the Blackfeet or were what he described as a war zone, controlled by no particular tribe, and eventually some of those lands became known as a common hunting ground. Nevertheless, the tribe has consistently maintained that the occasional hunting and fishing that occurred intermittently by the tribe is enough to assert an Aboriginal claim to lands east of the Continental Divide. However, in 2012, the Ninth Circuit issued a decision entitled Native Village of Eyak, EYAK versus Secretary of Commerce. The site on that is 688 F 3rd 619 from the Ninth Circuit, 2012. And basically what that case states is that in order to assert an Aboriginal claim, the tribe must demonstrate that it had full dominion and control for a long period of time to the lands that supposedly those Aboriginal claims are on. This holding basically destroys any legal claim that the tribe has to assert Aboriginal claims east of the Continental Divide. It took me about half an hour to find this case, and took me another half an hour to find Dr. Farr's reports. And I'm not an Indian law practitioner, so it's difficult for me to believe that the proponents of the compact did not know about this. The Compact Commission a couple years ago, I believe actually a year ago in early 2014, issued a report basically summarizing the compact, or at least the compact as it existed at that point. And on page 7 of that report, the Commission talked about how Aboriginal claims by the tribe supposedly extend well into eastern Montana, almost 2/3 of Montana. And that Commission report stated that if the compact is not ultimately passed, then the tribe is threatened to file various water claims, thousands of water claims east of the Continental Divide. Nowhere in this report issued by the Water Commission was it discussed that the tribe really has no valid legal claim east of the Continental Divide. Compact has been sold to farmers and ranchers east of the Continental Divide based on fear and lies. Lies echoed by the governor and the attorney general and numerous dark money shills.
Oh my gosh.
They did this because they needed political support.
Representative Monforton, just go ahead and state your point.
They did this because they needed political support from east of the Continental Divide. This amendment will deprive the tribe of the ability to use frivolous claims to continue extorting farmers and ranchers east of the Continental Divide.
Representative Fiskus.
Thank you, Mr. Chairman. This and another issue called lachies I brought up at the hearing the other night. That was 30 hours ago. And we're doing a bill the size of Obamacare in less time than they did in Washington, so we're much more efficient. My question is under the Aboriginal rights is nebulous at best. I'll bring to your attention the Black Hills of South Dakota, where I was born and raised, and the Native Americans there claimed the Black Hills, and they would have gotten Mount Rushmore. I think that's ever happened. It started 20 years ago, and it was Aboriginal rights as far as I know. I could not check that out, the language of the bill, because I have a whole 30 hours to get it done, but I would put that forward. And then comes lachies, and Supreme Court Justice Ginsburg, in one of the flyers I got, and I hadn't checked that out yet, ruled that the claims of Aboriginal rights don't exist because time immemorial has gone by. They don't. It does go by in the case of lachies, and so they have had no claims. And I haven't been able to read that case, but it was brought up to my attention by one of the experts in the hearing the other night that you can't even use it because time's gone by. Billings is there. The water under Billings belongs to the state of Montana. They can't exert it. Here's in Helena. If you were to believe this, the Aboriginal rights, the water we're sitting on right now belongs to them if they want and choose to take it. And I think that's bogus, totally bogus. And thank you for allowing me to address this issue.
Representative Eck.
Thank you, Mr. Chair. As far as I know, the sponsors of these amendments did not participate in the commission. And we had hydrologists, experts in Indian law, state legislators, federal representatives, tribal representatives, anthropologists, all participating in these discussions and these hearings. These went on for over a decade. It's the height of greed and arrogance to be offering these amendments right now. I mean, this amendment relinquish all tribal rights and claims east of the Continental Divide. I'm stunned by how greedy we want to be. I mean, this compact the tribes give up so much, and it's not enough. And we want to come back after the limited discussion that we've been able to have, after the limited study we've been able to have, and say that we know better and that we should just swoop in at the last minute and undo over 10 years of work. We should trust our colleagues from both sides of the aisle who worked on this commission, who worked on this compact in good faith, who came up with a true compromise, and that's what we're sent here to do. And it's not easy, and we should respect the fact that they did the hard work. And all they're asking us to do is to trust in that. And instead, we're coming here and just gutting the whole thing and asking for the entire world. And it's what white settlers have done from the beginning, and we're still trying to do it, and it's shameful. I am truly embarrassed, and I apologize to the tribes.
Representative Hill.
Thank you. Mr. Chair, I'm going to ask that we end this charade. This is a colossal waste of time. We have, 4 to 5 more amendments to go? I would say, with all due respect to my friend from Bozeman, the sponsor of this amendment, and he is my friend from Bozeman, his admitted 60 minutes he spent researching a case to draft this amendment compared to the 10 years of research that the federal, state government, the biggest experts in the nation on water law and tribal law to work on this bill. I think this is, or the fact that Republican Attorney General Tim Fox has somehow perpetrated a fraud in cahoots with Governor Steve Bullock against the farmers and ranchers of this state, I think it's borders on absurd. And I think it's emblematic of the type of opposition that we've heard to this bill, with all due respect, my friend from Bozeman. I do want to say this, because there's 5 members of this committee that sit with me on the House and Human Services Committee. I would say this. Before we waste another hour going through 4 more amendments, we know where they're going. Just move them all at once. I've been on the Human Service Committee. I watched what the majority leadership is doing. Chair Artwiddick did the same thing with Medicaid expansion. Amend the bill. My friend Representative Haas, she moved to amend Medicaid expansion for a totally substitute bill. And then at the end of it all, it was a do not pass. Well, we have the silver bullet letter. We know where this is going. Let's quit the charade. Let's quit pretending like these amendments are meritorious or that we believe in them. Let's end it. We know where this is going. Move all 4 amendments. I ask, as a courtesy to this body, this institution, and the integrity of all of us sitting here. This is the minority part of this legislature trying to control the will of a bipartisan majority, and everyone at this table knows it. I'm sorry that's happened, but there's 2 sides of the aisle working together to see the good of Montana in this compact pass, and it will pass.
Representative Kelker.
Mr. Chair, I have a question for Ms. Thigpen.
Ms. Thigpen.
And I'm inexperienced here, so I'm not sure, but I kind of have a legal question. If you can't answer it, I'll understand. But it appears that this particular amendment would create an aspect of state law that says the tribe could not pursue their rights. And that would seem to me not a power that the state would have, the legislature would have. I mean, can we put into law something that says the tribe cannot pursue its rights? I mean, that would be a federally protected right, I would think.
Mr. Chair, members of the committee, Representative Kelker, this would be an amendment to the compact that was negotiated by the Compact Commission, the United States, and the tribes. So you would essentially be amending this compact to do that. Again, because it would be changing that agreement that was entered into, the parties would essentially, I believe, have to agree to those amendments. And to be honest with you, I'm not entirely sure what the effect of that would be if this were to pass in that fashion. I'm sorry, I can't give you a better answer than that. Certainly, I believe that the tribes would potentially have the right to pursue those claims regardless of what was put into this negotiated agreement, Mr. Chair.
Thank you, Ms. Thigpen.
Representative Monforton.
Thank you, Mr. Chairman. To answer that question, this amendment would have no binding effect on the tribes unless they accept the compact as amended. But its Aboriginal rights are like any other rights. They can be properly waived.
Any questions been called? We'll do a roll call vote.
Vice Chair Doan.
Yes.
Vice Chair Court. No. Representative Kelker.
No.
Representative Burgley.
Yes.
Representative Pinocci.
Yes.
Representative Fiskus.
Yes.
Representative Eck.
No.
Representative Perry.
No.
Representative Monforton.
Yes.
Representative McDonald.
No.
Representative Hill.
No.
Representative Pease Lopez.
No.
Representative Laszloffy.
Yes.
Representative Manzella.
Yes.
Representative McConnell.
No.
Representative Hess.
Yes.
Representative Myers.
No.
Representative Wagner.
Yes.
Representative Pearson.
No.
Representative Regier.
Yes.
Chairman Bennett.
Yes.
Mr. Chairman, the motion on SV 026271.AJM carries 11 to 10.